page 11, which is Canada. Then, my Lord, will go to, my Lord, page 12, which is South Africa and Australia. Page 13 is the United States. Page 17 is Thailand and Nepal. And, my Lord, I must just tell your Lordship about Nepal, because they answered the question squarely. Does it degrade the institution of marriage to have a provision which penalizes the husband? And the Nepal Supreme Court, my Lord, at page, I'll give your Lordship that page, at page 23, very nicely answers the question, saying it is precisely the opposite. Having violence and rape within marriage degrades the institution of marriage. And penalizing it, criminalizing it, actually purifies the institution of marriage. Very nice answer, my Lord, by the Constitutional Court. Then, my Lord, at page 25, page 24 and 25 is France, Germany, Belgium, Netherlands, Italy. So, my Lord, right across the world, you have constitutional judgments, setting aside, my Lord, this exception too. Then, my Lord, from 25 onwards are the international conventions, which specifically say, my Lord, that marital rape is rape. Page 27 is the recommendations of the Justice Verma Committee. Page 29 onwards, my Lord, in response to an argument made, my Lord, by the government before the High Court, that this is a Western concept, and that, my Lord, is not true in India, etc., etc. We have attached, my Lord, 2 UN reports, where, my Lord, in UP, Rajasthan, Haryana, men were interviewed on whether they have sex with their wife even when their wife say no. And startling statistics emerged, showing that 40% of men openly say, yes, we do, and it's not a problem at all. Then, my Lord, at page 31 is the UK Law Commission report, which we used in the High Court, my Lord, to answer the objection taken by the central government that once you make it a crime, wives will litigate against husbands.
Only one clarification. Central government didn't argue before the High Court. I think my learned friend seems to be under a wrong notion, because he keeps on saying that to meet with this contention, to meet with that contention. We never argued before the...
All right. So, my Lord, this is page 31. Leave it. That, my Lord, it will result in chaos. There'll be a floodgate opening of litigation by wives against their husbands. It'll be impossible to prove. The Law Commission dealt with that it happens within the confines of a room, a bedroom in privacy. It'll be impossible to prove. So the Law Commission deals with that argument as well.
Where do we get that?
That is, my Lord, page 31 is the UK Law Commission working paper, Rape Within Marriage. And this was commissioned, my Lord, after the House of Lords, my Lord, held it to be unconstitutional and did away with the exception that Lord Hale had instituted, my Lord, hundreds of years back. So, my Lord, that is. Now, my Lord, at page 38 onwards, justifications for retention of exception 2. And the question was raised as to was the legislature right in providing all married men criminal immunity against their wives in rape cases? Number 3, whether the Constitutional Court, while deciding the issue of constitutionality, also look into the issues of difficulties that will arise in proving rape within the confines of it, etc., etc. And the general, my Lord, consensus of the courts are that once we declare the law and hold that the exception is not valid, Then, my lord, the law will have to work itself out and by practice, my lord, sort out how. My lord, in the case of a husband raping his wife, how prosecution will be done. That is, my lord, 3940. Somehow, in a marital relationship, if rape takes place, the punishment should be less than the punishment for rape generally. Page 41. And, my lord, what the courts have said about that. Then, my lord, page 42. We dealt with the argument that 498A exists, other punishments exist for other crimes connected with rape. Therefore, that is good enough, and it is not necessary for India to go the route of criminalizing. Then, my lord, false cases at page 43. The argument that it's 43, and it became, the argument used was, it would be, middle of page 43, it would be an easy tool for harassing husbands. Floodgates of false cases would be made, etc., etc., etc. Then, my lord, the page 44 was the argument made. 44. This might have, my lord, some connection with my lord Justice Pardiwala's question, but I want to answer that straight away. The argument was made before the High Court that a husband has a right to expect sex. And perhaps that might be correct to some extent, but to answer your lordship's question, a wife may be unreasonable. She may say no. Let us take it that it is unreasonable that she said no. But once a wife says no to a husband who says, I want to have sex, and assuming that she's being unreasonable, in all situations, once a woman tells her husband no, it becomes a no.
It becomes a
no.
no.
There is no exception to that. And your lordship asks, can she go and file an FIR against her husband if there is rape within the marital home? The answer is yes. And right across the world, if a woman says no, it is no.
Okay.
Yeah.
Come to section 67.
Yes, ma'am.
Assist us on this short point.
Yes, ma'am.
Again, I am putting a hypothetical.
Yes, ma'am.
Right?
I understand. Yes.
You said no, correct? A big
Yes,
no.
ma'am. Yes.
She is tired. And one fine day, she decides to leave her matrimonial home.
Yes, ma'am.
And goes back to her parental home.
Yes, ma'am.
Or she goes to anybody else's residence.
Yes, ma'am.
What do you mean by under a degree of separation or otherwise? How do you construe this word otherwise in section 67? Because
Yes, ma'am.
it constitutes an offense.
Even within the fold of marriage.
Even within the fold of marriage,
Yes, ma'am.
legislature has thought fit to say sexual intercourse by husband upon his wife during separation.
Yes, ma'am.
But the statute, the provision says whether under a decree of separation, one can understand.
Yes, or otherwise.
There is a decree of divorce,
Yeah.
everything goes.
Yes, ma'am.
They cease to be husband and wife.
Yes, ma'am.
If even there is a decree of separation,
Yes, ma'am.
which is distinct from a decree of divorce.
Correct, ma'am.
But what do you mean by or otherwise?
That means, my lord, if there is no decree of separation, but the wife is living separately, in fact,
That's your argument.
that's my argument, my lord. The wife has separated, she's moved to a place, she's living separately, they've not yet got a degree of separation. And then the husband says, listen, I'm still married to you.
Offense as long as she is at her matrimonial home.
No, my lord, I'm not saying that. I'm saying that wherever the wife may be, if she says, yeah,
67, this question would not have cropped up. The legislature in its wisdom has thought fit to make this an offense. That if
Yes.
a husband has sexual intercourse, because you see the heading, sexual intercourse by husband upon his wife during separation.
yes, ma'am.
What do you mean by separation?
What I mean by separation is, my lord, if the court says, yeah,
Question.
yes,
When the provision says decree of separation,
yes, ma'am.
is the marriage still subsisting or it's just a decree of separation? For a couple of months, the spouses will live at a different place. They will not reside together. In 67, whether the marriage still continues, subsists or not.
It may subsist, my lord. It doesn't matter really. If it's a divorce and the separation is permanent, that's separate.
Before divorce
Yes.
stands on a
In fact,
different.
Yes, she's separated. Yes,
67 postulates that the marriage is subsistent.
correct.
Because it says
Husband.
with
Yes.
his wife.
Yes, my lord. So you're separate, but your marriage is intact. Now the husband forces himself on the wife when you all are separate, but your marriage is still intact.
So even within the fold of marriage, 67 postulates that there could be a rape.
Yes, of course, my lord. It's an absolute no, my lord. Now the argument is a practical one, and that's why the Law Commission report, which I
Now, the
read out.
difference between 67 and exception 2 is that exception 2 applies in a situation where they are not living separately. They are living together, but she has said no for that particular act of sexual
Yes, my lord.
intercourse.
Yes,
67 applies to a situation where they are living separately.
yes,
Living separately means that, well, there's no intention now to cohabit together.
yes,
It has to be ejusdem generis. Brother Mishra just said it has to be read ejusdem generis.
yes,
As in the case of a decree for judicial separation, where the postulate is that you're not going to cohabit together, though you are still married as husband and wife,
yes,
or otherwise would refer to such situations where you're not actually separated, you're not actually divorced,
yes,
but there is an intent not to cohabit together as a result of which parties are living together.
yes,
It will not refer to a situation where a husband is employed in a different city or a wife is employed in a different
Yes.
city, because there is an intent to cohabit, but
Okay.
for reasons of whatever your immediate circumstances, you are living separately.
Yes.
That's not the 67 situation. Living
Yes.
separately or otherwise, who is living separately means not living in two different locations, but where there is an intent not to cohabit.
yes, yes.
If I may say so, the legislative history of that amendment or otherwise, it came in 2012. It was not there prior to 2012.
Can you just give us a small note of a page or so on that?
Yes, I can give you the legislative history of the addition of those words or otherwise. To the extent that I have knowledge of it, it may not be recorded anywhere, but this is a fact that it came in 2012. And my lord, if I may just tell you, its origin seems to be that when you file for mutual consent, you have to be living separately.
Right.
That's a condition for divorce by mutual consent. But this issue came for interpretation before the courts that what is the meaning of living separately? Does it mean living under two different roofs? Or can you live separately under the same roof? So the courts have held that you can live separately under the same roof. It goes to the intention that my Lord the Chief Justice said that we do not wish to cohabit with each other in the matrimonial sense. So even though you're under the same roof but living separately, this section will kick in.
It will kick in.
It will kick in just as mutual consent kicks in. So mutual consent also can be granted if the people plead that we have been living separately, though under the same roof.
So living separately is not that you stay in two different physical locations.
No.
You may be in the same physical location.
Yes.
But there is an intent not to cohabit together.
That the intention to have conjugal relations
Has ended
ended.
for the present point of time.
Yes. And my lord, one of the reasons it was introduced, to my knowledge,
That came in by Act 13 of 2013.
2012.
13. Act
Yes.
13 was actually, it was brought in 2012.
It was,
The,
yes,
the
it was
assent was early, maybe have been January, February
the
2012.
Nirbhaya amendment. It came after the Nirbhaya, after Justice Verma.
Right. 376 came in, 376B, with retrospective effect from 3rd February 2013.
It came in 83.
No, that was an earlier.
Earlier, no,
That was public servant.
No, Manoj, there
No,
was 76A which dealt with this, and it read intercourse by a man with his wife during separation. Whoever has sexual intercourse with his wife who is living separately from him under a decree of separation.
That's it.
Or
You're right. I got that.
Yeah.
The footnote to page 151, if you have got the same book.
what renumbered by
So,
2013
376A
as it stood prior to in 1983.
stood as under.
Then it
So
gets
where
amended in
custom and usage is removed and lives this is brought in the
Right. So 376A, as it then stood, but it covered only under a decree of judicial
Yes,
function.
yes, my
or
lord. Yes.
custom or usage. Please see that.
Yes,
Yeah.
or under any custom or usage.
Formality that is attached to it.
No,
It's
my
not
lord,
an
what was
informal-
Then
happening?
what they did was in
That was-
2013,
Custom.
they removed custom and usage and said
Or
decree
otherwise.
for judicial separation or otherwise.
Well,
You got it.
It's not my place to
Yes.
comment, but the
No,
petition.
thank you. Thank you.
Therefore,
Place
not-
the legislative history a little before.
Therefore, the key, my lord, the
We
key.
have, my lords.
Key
It's
is
in-
intention, my lord. The key is
There are more of us to come.
And my lord, the problem arose because
My
of,
friend unfortunately has started a world tour. We are into Manoj, a European context.
but this is.
So I'm
Indian
coming to that.
Explaining, Mr.
So
Tushar.
no, I'll finish quickly now. 10 minutes, I finish. I don't want to take
No.
up
I am talking about Colin Gonsalves.
But,
not
lord,
you.
but I'm on my legs. My
Ma'am,
lord,
I'm sorry.
my lord,
I think he was really referring to Mr. Gonsalves' written submissions, not about you, Mr. Singh.
my lord, just one last.
Calcutta matter also, Manoj, I am always, Manoj, fearful of standing beside.
No, my lord, I'm on his side. In the Calcutta matter, we are on
Yeah.
the same side. Why are you afraid of me?
For the first time, I realized that being opposed by her and being supported by her is the same thing.
That's a huge compliment to me, Mr. Mehta. A huge compliment. Thank you. But if I may just conclude
well
with
said,
one
Mr. Tushar.
sentence, my lord.
Well said.
The problem was decrees for judicial separation were taking forever. That was the issue. Why?
Mr. Singh, the Solicitor General is complimenting you for your fierce sense of independence.
Yes.
My lord, I think he wants me to sit down, so I'll do that.
But just give us, as Mr. Dave said, just if or anybody can, just one page of, the.
I'll do it. Manoj.
Please do that.
It was just so happened. I know this because at the relevant time in 2012, when the amendment,
It originally came in 83.
yes, 83.
Which said judicial separation, custom or usage.
Yes.
2013, the judicial separation is expanded by using the words or otherwise. Custom and usage goes out.
My lord, with respect, I'll repeat once again. The question is intention, as my lord put it. You do not intend to
Intended to
cohabit.
cohabit as husband and wife.
You want to live. You don't want that conjugality. That is the intention. That's why you're living separately. That was the intention behind introducing or otherwise.
So, my lord, I'll
What
finish.
else, Mr.
Yes,
Gonsalves,
yeah,
now?
I've come to the end.
We'll look at your.
So, my lord, the first part, which I read out to your lordship, but I didn't read the judgments. It seems to be pretty well settled in the world, in constitutional courts, that the exception is unconstitutional. So there's a strong persuasive value that your lordships may agree to follow that line or distinguish it. Now, for India, a special argument was made at page 51 onwards, which is met by the UK Law Commission report, which studied the effects of the court outlawing marital rape. Page 51. And exactly the same arguments were made in India. I'll just read this one page. First, my lord, that there should be a separate regime of sentencing for marital rape. That is A. And the report says there's no reason, no factual or legal basis for this. Second, that there would be humongous problems in prosecuting persons who engage in marital rape because it takes place in the confines of the room. They said no. C, there will be enormous difficulties of proof, evidence, proof in marital rape cases. The Law Commission said it doesn't seem to be any different from normal crimes. D, balance of credibility, that there'll be a single witness who's the woman who's been raped, the wife saying, they looked at that and said no. Next is, my lord, even if there's only one witness who's the wife, courts would be capable of identifying testimony that it was in fact credible and acting on it. And finally, the wife would feel tempted to make serious allegations against the husband. They found that there was no evidence of that, even 10 years after the law was changed. Next, my lord, next page, and I'll finish very quickly. Page 52. The existence of an offence, this is very important, my lord, would itself tend to deter the conduct of marital rape. You would not need wives to go to courts and punish their husbands. In fact, the finding was that wives are very fearful of prosecuting their husbands even after, my lord, rape takes
Have you seen that?
etc., etc. My lord. These are, your lordship will see this. Page 53 is a new aspect, namely, in the UN, where, my lord, it's called the Universal Periodic Review, where countries are subjected one by one on aspects where the national law has not met international standards. And on marital rape, my lord, we were found to be seriously lacking. These are the countries which make recommendations in the UN, very politely, very, my lord, in a very civil,
That's all right.
saying that we, yes, lord.
Into the constitutional.
Finally, my lord, turn to the Nepal judgment, just a paragraph from the Nepal judgment on how the removal.
Where do we get the Nepal judgment?
Yes, my lord, page 23 of the same.
Okay, we'll look at it.
Page 23.
We'll look at it.
That criminalizing rape, marital rape, purifies the institution of marriage.
Okay,
It doesn't undermine and denigrate it. Grateful,
So
my lord.
what, thank you, Mr. Vincent.
Yes, Lord, great.
What we'll do is we'll break here. It's about 3:50. Mr. Shankarnarayan, we'll hear you next. After Mr. Shankarnarayan on this side, who is going to argue?
I just wanted some clarity. If your lordship would want me to address the interpretation so that it goes
I
along.
think so, yes. But without going into the facts of your case.
Yes.
But we'd like your assistance because we have.
Can I just
consolidated
clarify one
assistance
thing?
on this side.
Could do
Because
that.
there was a split decision in the High Court, there is a appeal coming the other way as well, against which will possibly argue with the respondents. Technically,
So we are dealing with the 32 petitions essentially. But
Essentially, the proposition which is being tested, my lord,
That's right.
SLP
So
or
about half an hour from Mr. Shankarnarayan on Tuesday.
then I'll just.
And then, Mr. Shankarnarayan, you have circulated your submission?
I've
So over the weekend we'll,
find it's very detailed.
speaking for myself, I have long flights over the weekend, so they're always an
reading material.
What,
Your lordships may
one
not
is
waste,
either
my lord.
typing one's
Let me just-
judgments out or reading on.
Your lordships may not waste, my lord, flying time on reading this, my lord. There are better things, my lord, in.
I've
for
actually
read-
I've actually made it quite entertaining with pictures and stuff, so it may be more interesting than Mr. Mehta thinks it is.
Oh, I see.
And secondly,
Subject like
the
Mehta.
the canvas is actually a little wider.
That's why we look at your
Many more,
submission.
including these sections 67 are all under challenge in this.
So we'll closely read your written submission.
Right.
So now on this side, Mr. Shankarnarayan, followed by Ms. Jaising on interpretation.
Yes.
And after that, then the solicitor, you lead solicitor? Okay.
There's one thing which was fallen from Justice Pardiwala, specifically on consent. The first clause is against her will.
Against her will.
So will and consent, that is going to cause considerable, from our side, the arguments are going to be on that. That may be kept in mind by on that.
I'm not, I
And irrespective of your mind, if you want to take 10 minutes to just highlight some of the important issues, the ways which we are.
Even what he said will.
It's the election, seal number 30 for petition.
Section 30.
Who's appearing in this matter?
Item 34.
Yes, Lordship. I am.
What are the reliefs which you are seeking in this matter that we should injunct the Haryana government from taking oath?
Oh, Lordships,
They've taken oath.
Lordships, my prayer is here कि I filed the presentation, Lordship, before the election commission, give the directions, this pending application decide in the time bound manners. Is in Lordship, I was saying that early morning, Lordship.
Kind of petitions are these?
Okay, Lordship.
Direct the ECI to conduct the re-election in 20 suspicious Vidhana seats.
Yes, Lordship, because there is the 70 to 90% battery has been charged found out the election commissions as per the laws, Lordship, which is already annexed. In these presentations, Lordship, same entire